And so the other thing that I wanted to raise, and this is really important, the notwithstanding clause is in the Charter of Rights. I don't like the notwithstanding clause. Don't think it should have ever been there. But I respect it. It was part of a historical compromise. It's there. But there was never an understanding by those who first adopted the Charter that the notwithstanding clause would be used preemptively, whether it's with respect to labor rights in Ontario or whether it's respect to language rights in Quebec. The understanding was you would pass a law, it would go to court, the Superior Court of the province, the Court of Appeals of the province, the Supreme Court of Canada would decide. There would have been a big societal debate. And then afterwards, if a province wanted to use a notwithstanding clause, they could, but they would do so in the full knowledge, and more importantly, in their population's full knowledge, that the courts had said that this was a violation of the Charter, that it was the suspension of a right or the limitation of a right that wasn't reasonable in a free and democratic society under Section 1. And to me, by not supporting this, we're essentially saying that we agree with the preemptive use of the notwithstanding clause, which the federal parliament has never adopted. We have at least two parties in the federal parliament that have come out foursquare against the preemptive use of the notwithstanding clause. Our Minister of Justice has said that we're going to challenge this in the Supreme Court in the Bill 21 case, or who knows, we may do a reference. How would this undermine that reference or our arguments in the Bill 21 case in the Supreme Court if our Minister of Justice and Attorney General is arguing the preemptive use of the notwithstanding clause is unconstitutional, and the governments of the provinces say, but it was referred to positively in your own federal law, Mr. Attorney General? That, to me, is a major, major issue, and I cannot imagine that that would be helpful to our case or the federal case. And by doing this, we're undermining potential cases we may bring.